A very good afternoon to everyone present here. I, Navya Saxena, student of BBLB Semester 4, am ecstatic to welcome you all to the Personality Development Workshop on Logical Thinking and Judgmental Skills organized by Center for Legal Studies, Gidarathan International Business School. Gidarathan International Business School was established in the year 2004. The institute is affiliated to Guru Gobind Singh Indraprasth University, Delhi, and is approved by All India Council for Technical Education, Ministry of HRD, and Government of India for technical programs and Bar Council of India for law programs. Currently, the institute runs management and law programs that are highly sought after. GIBS has been graded A by National Assessment and Accreditation Council in second cycle. It has also been rated A+ by State Fee Regulatory Committee, a committee of Government of NCT of Delhi, and rated highest grading A by Joint Inspection Committee of Government of NCT of Delhi and GGSIP University. It has been graded A by Academic Audit Cell of GGSIP University consecutively from past 8 years. Further, GIBS has been rated as number 2 pan-India by Times Business School Survey in 2018, 19 and 2021. Lately, as another feather in the cap, GIBS has received 4-star ranking Institutions Innovation Council, Ministry of Education in 2021. This workshop will, among other aspects, help equip the students with requisite logical and judgmental skills as they to create a need for skills in the demanding law profession. Since critical and logical reasoning forms the core of skill expected from industry-ready students, budding entrepreneurs, it becomes imperative part of the college and universities to impart such skills to their students. For students of law, a film a field inherently based on reasoning and sound judgmental skills, the effort skills act as fulcrum for decision making. A student armed with logical and judgmental skills is able to apply relevant and well-focused questions to information and opinions and questions, critique and challenges the ideas in class discussions. Also, such skills help see clarity, consistency, and accuracy. A student thus becomes interested in the causes and implications of events, systems, and ideas. To enlighten us on the topic at hand, we have a distinguished speaker in the form of Honorable Justice Zaki Ullah Khan, High Court of Judicature at Allahabad. In a defining career spanning nearly 4 decades, Sir has worn many hats. Lawmaker per accident, Advocate Supreme Court of India, Legal Referencer, and Principal Secretary Officer on Special Duty, appointed arbitrator by Delhi High Court, magistrate, and judge. All this and still gracing the profession with his practice in the Supreme Court of India. We heartily welcome you, sir, for enlightening the occasion. We are privileged to have you over and anticipate a lot of takeaways for the students from your session. Without much ado, I would request, sir, to take over and address the audience. So, please.
Okay. Probably I am addressing to the students of semester 4, that is second year students. Am I clear?
Yes, sir. Yes, sir. Absolutely.
As far as these children are concerned, as the students are concerned, this semester 4 is just a beginning of the law. In fact, you have not started, in fact, the true law, that is the other law concerning with the Bear Acts and all that. And you have just started trying to come over in the field of law. The judgment skill is one of the best things which a person should learn while becoming a judge or an advocate or at least a law professor, because judgment is the crux of all things which ever happen in the court of law or outside, or whatever you read in the books and other things. Thing is that there is one term, that is ratio. That is ratio descendi. That means whatever judgment has been given is based on some fundamental principles. That is called the ratio of the judgment. And what is judgment? In fact, judgment is nothing but a juxtaposition. That is the mixture of all the facts, issues, and everything. There are two types of cases. That is the civil cases and the criminal cases. For at least for young children or young students are concerned, I must say that they should not go into the deep details of constitutional law and all that. Only thing they should study, they should know at least what law is, and law is probably known as the general law. What you think is that the either criminal law or the civil law. The first of all, I'll take the criminal law, because criminal law in daily life you may come across so many things which attract you, because that what is criminal law? Criminal law is that is if an accident occurs, or if somebody takes some small battle or some other thing, and they try to beat another person, and then the dispute arose between the persons that who has beaten and who was at the who was on the attacker side, and who was the person who incited everything. This is called the criminal instigation of the thing. Whenever such thing happens, person is that the person is the victim, the person is the offender. That is the person who has taken law in his own hands. Law, as you must know, is nothing but by the common concept of community. That is what Austin has said, that by common concept of community is something which has been imposed on the society with the will of the society, but with a sanction behind it. That is there must be someone who regulate, and someone who regulate is the person is a judge, or initially the police, and subsequently when the police send the case to the courts, then it is judge. Sanction is that. Sanction means that is the power of punishment, the power of control, the power of everything. That is, without sanction, nothing is there. Therefore, whenever there is a distinction, whenever say the person says that they have committed, certain person has beaten him or certain person has assaulted him, then that's a crime, and that crime goes to the police, and the police registers the case and then investigates, and after investigation they submit the charge sheet, and after when the charge sheet is submitted, the other person is either being arrested, being taken to custody, and then he produced before the magistrate, and then the long process, that is the evidence and everything, and the defense, and then arguments, and then the final case, the judgment. Then this is the judgment. But what about the judgment? Judgment as defined in the Code of Criminal Procedure. Code of Criminal Procedure is given in the section 353 of the Code of Criminal Procedure, in which it has been written that what is judgment and what type of judgment is, and how the judgment, what judgment should contain, and therefore all these things combined is a judgment. And whenever there is a dispute as to how the things happen, this depends on the circumstances, and all the circumstances revolve around the case. These are the things in which, say, if the heinous crime is committed, then the heinous crime is takes much more other than these usual steps. That is, the crime is registered at the police station, and the police arrest, and then the police searches. That is the offensive weapon for which he attacked and in which he killed. Then the entire matter goes to the police, and the police then, after investigation, submits the charge sheet, and then it goes to the magistrate, and the magistrate commits it to court of session, and then session courts say that ask the person that you have committed. If he says yes, I have committed, then he is convicted, and if he pleaded not guilty, then the trial starts, and then the real sense of judgment arose. That is arise. Then whatever he says that he doesn't plead guilty and he needs to be defended, and then he plays his own pleas, and then the prosecutor, and initially the burden lies on the person. Initially the burden lies the accused. No, sorry, the burden lies with the prosecution. That is, prosecution has to establish that the person who is being implicated has committed a crime, and with all humility and with all deliberance and the whole vigilance, it has been seen that he has committed the crime. He is the only person who has committed the crime, and these are the evidences which are against him. This is but there is exception. There is exception. That exception arose due to certain laws prevailing now. That is the Dowry Prohibition Act and all the Gangsters Act and the OPM Act, another act in which the the position is different. The prosecution is not at all bound to establish that the person who is facing the trial is guilty, has committed the offense, and the person has to, now the person himself says that I am innocent, and the other person should establish, the court, the person should establish in the court that he has not committed any crime and he is not guilty. And the other, then in rebuttal, then the prosecution will submit that no, he is telling lie, and these are the examples, and thus the recovery has been affected from him, and this and that, and he has been caught with certain contraband, and he has been caught with the weapons, and he has been caught with other things. Then similarly, in the dowry death case, there is no one else inside the room. If a husband killed his wife, then there is no one else. Therefore, the duty costed on the husband to establish that he is not guilty and he is innocent. Otherwise, in all the other cases, the person is supposed to be innocent unless until proved guilty. These are the basics of the criminal law, and the criminal law is based on the Anglo-Saxon tradition and Anglo-Saxon laws. Anglo-Saxon law says that the person cannot be held guilty unless until he has been adjudged guilty by the prosecution, and the burden entire lies on the prosecution. But there's a difference between the Anglo-Saxon tradition and the Indian laws. Although we are following the Anglo-Saxon laws and as well as the Indian Anglo-Saxon tradition, but the thing is that under certain circumstances, the Anglo-Saxon tradition says that the confession, that is, if a person caught while police seeing the crime, then he is said to be, when he is confronted with the facts, then he will say that yes, I have committed the crime. Then this is a sort of confession to the police. But here in Indian law, the Indian Evidence Act says that confession will not be relevant in the Indian courts. The Indian courts are not bound to accept the version that he has been found guilty on the basis of the police record. The police, whatever police says, the police has to establish in the open court. That is, the evidence has to be given, and therefore the big role of the judgment before the judgment is that of the Evidence Act. The Evidence Act says the Evidence Act lays down the provision. Then how the person has to establish, the prosecution has to establish, and the reply, the accused has to give his defense. The prosecution is duty bound to produce entire evidence as per Evidence Act. What Evidence Act says that there section 3 says that what are relevant fact, what is fact in issue, and section 6 of the Evidence Act and section 8 of the Evidence Act, previous and subsequent conduct of the accused, the person who has committed a crime or who has been facing the trial, and he has to establish that he has not committed a crime, and that all the conduct and motive, preparation, everything that has to be seen, and that has to be established by the Evidence Act. Then Evidence Act certain lays other grounds also, the presumptions, and as far as the Dowry Provision Act, under section 113, the presumption is that under certain circumstances, say that if the person is found with the stolen property soon or before after the theft, then he is supposed to be guilty and the burden lies on him. Similarly, there are other things which establishes the prosecution to establish and the way in which the evidence has to be led. These are all regarding the criminal law. But one thing is that criminal law, there is something which is essential is that of the intention. The criminal intention, that is mens rea, is one of the foremost important thing that the person should, if a person has committed crime, that is the accused who is facing trial must have mens rea to commit the crime. Unless this is established, that is, if no mens rea, that is, if he is innocent, he is a unsound mind and he is otherwise incapable of doing the crime, how can he commit the crime? Therefore, mens rea is the first ingredient. And other thing is that the attempt. And the third one is a crime. And as far as regards the preparation and other thing, that preparation is preparation though, but motive and other thing is also relevant for this regard. And the other thing which affects the criminal trial is that the intention, the motive, preparation, and then commission of the crime. These are all things. But if a person thinks was only thinking that he is going to commit crime, this is no offense, unless until he is in league with the other person to have a conspiracy and to discuss the thing that he will do. Then that will be conspiracy and that will be actionable. Otherwise, the only thinking and the making plan is not permissive and will not constitute any offense unless until it is supported by another person. That is when two persons are united and the two persons think that they will commit a crime. Then that will be offense. If a person himself thinks that he's going and he's such type of person and he will go do all these things, then it will not be a crime. But only thing that when the meeting of mind is there, then they supposed to be commit crime. And that is the similar thing is that there is a section 34 of the Indian Penal Code which says that in furtherance of the common intention, when a group is committing the crime and the group is committing some mischief, then that will be treated as how they can commit because of the common intention. What common intention is? Common intention is that the in furtherance of the some object, in furtherance of the some common thing, they met and united and attacked the person. They say that the mob attack and other thing, but there is in furtherance of common intention, that means less than 5%. If the 4 or 4%, the group of the persons commit the theft and something like each one be guilty under section 30, the original section, the dacoity section or the theft section, read with section 34. That is, each one will be liable, although he has participated in actual act or not. But because of the common intention, they will be liable and prosecuted. Well, other section is 149. That is whosoever in furtherance of common object. That is, whenever there is a crowd and the crowd is intention of the crowd is that to kill certain person and they started. It may be possible that initially the crowd maybe not be a violent on code may not be the crowd may not be not be criminal with criminal intent, but subsequently when they say that some of the persons come and say that kill them whosoever meet, then that will be this will be actionable under section 149. And each one, if the murder is committed by one person, each person who is accompanying that shall be liable under section 302 read with 149. That means the person who has not crime, but in fact committed crime, but in fact who was in company of those persons, that is the person forming a mob, then each person will be liable of the same fact. That is the same as Babri Mosque. Initially, the mob was not violent, and the sub person was apprehending, and sub person was asking that not to go, not to do unlawful act. But subsequently, they erased the mosque. That each one who had participated automatically became member of the unlawful assembly, and unlawful assembly is to be punished with the severity and with this in the same sense with each of the person. Lord Dacre's case is very famous in regard to section 34. Because Lord Dacre's Lord Dacre's was miles away, and he pronounced that he shouted that whosoever in come in way, he should be shot dead. Then the person was shot dead by the other person, and Lord Dacre, while trying at the time of trial, said that I have not shot him dead. So it was the theory that whosoever meets and whosoever in collision do all these things, that will be liable, equally liable to that. And therefore, the judgment will go around all these things. That is, the prosecution has to establish in accordance with the Evidence Act and in accordance with the Code of Criminal Procedure. In the Indian Penal Code, the sections are there, the law is there, but Code of Criminal Procedure says that how this is to be laid before the Court of Justice, and the magistrate or the session judge, whosoever may be, are doing the trial, is supported by going through by the provisions of the Evidence Act and the Code of Criminal Procedure. And whenever they unite, and that is to become a trial, and the trial after that, if he is adjudged guilty, then he has been asked to adduce the defense. Okay, if he wants to say something, and if he doesn't say anything, that means he has been sentenced. And after before the sentence, he has been given an opportunity that he may say something, and he may say something in his defense or some lenient punishment or something. He has got that liberty. But other thing, in case in case the person is sentenced to death, if a person is found guilty under section 302, because in 302 the murder case there are only two sentences, that is life imprisonment and murder. Life imprisonment, the provision is that the judge's judgment is final, and that is. But in case of sentence that the judgment is not final, the judge pronounced a sentence that will be provisional, and that it will be sent to the High Court, and unless High Court confirms it, then only it will be judgment in terms. Then he will be sentenced to death. Otherwise, he will not be sentenced to death because that judgment is not final. But up to the life imprisonment, if he has been sentenced, that is final and liable to for the appeal. So there are the few distinctions of this criminal law and civil law, and other cases in which the person is going, that is the NDPS Act, the Gangsters Act, and the UPCOCA and the MACOCA and all the special act. There's nothing, no liability on the prosecution to establish that he is the person. Only thing that has been arrested in such and such act, and that liability lies on the person who has been arrested to establish that he is innocent and he has not committed any crime. This is a major difference between the latest act which are prevalent, because the law of land is a code of criminal procedure and code of Indian Penal Code. But these are the special act. The special act will prevail over the general law if that has been instituted, that had been created afterwards. Because a special law is one of the things that has to be taken over and above the general law. And one of the most important thing in the criminal law is that section 106 of the Evidence Act. That is 106 of the Evidence Act says that whosoever was present in that. That means, say for example, because you can understand by example, if a person is found without ticket in the train, then it shall be presumed under section 106 that he was without ticket. But the burden is on him now. In ordinary cases also, wherever the prosecution is liable to set up the case, the person, the burden lies on him that he is the person, because he was found without ticket. Then liability is on him to establish that he purchased the ticket, is lost, and or he didn't purchase the ticket, because all these things are in such a nature that the liability in and on the basis of this, the Dowry Provision Act and the presumptions on the under Dowry Provision Act are laid down because of following the principles of 106 Evidence Act. Because if a crime is committed inside the dark, in the dark and inside the room where there was none, then who will say anything? The person, only the who has been who is coming out of the room, that says why, how, in what circumstance he has been killed, or if not killed, then you will be held guilty. And when I was posted in Agra as additional session judge, I just tried. A law college was being built, was in construction stage, and three persons were living inside the terrace of the servant room. Both the chowkidar and one of the guards. One person was died, one person was witness, and other person was victim. And how can we evaluate the evidence? Three persons were there. One died. One is witness and one is the victim, and one is the assailant. And the person is that, and I evaluated all the evidence, and when it was seen that, and when it was then the police, the prosecutor interrogated and everything, defense counsel, then they're on their own discussions and their own cross-examination, the truth came out and the person was held guilty. So these things are sometimes happen. These are not definite. The criminal law is not a definite thing. It depends on the facts and circumstances of each case. Sometimes this way, sometimes that way, and so many things which come together or which combine together will form a law, and that is on basis of which the judgment is to be recorded, and the judgment is supposed to be, and since this is a what you call that, the judgment is not final, because the judgment of the trial court is not final. Therefore, all the other courts are being met. That is, the appeal lies to the High Court, and after that, the special leave petition lies to the Supreme Court, and there's a review and other provisions there. And therefore, the judgment of the trial court is not final, because of thing that to check arbitrariness, to check illegality, the other opportunity has been given to the persons who are facing the trial and who are being victim, and say that they have been acquitted, then the victim has got right to dispute and appeal before the High Court that he has not been given a fair trial. Therefore, these are the things which the judgment should contain, and judgment should be judgment should be such as to elaborate each and everything. That is the fact and the fact in issue and the relevant fact on which the judgment has been based. All the facts are not important. There's so many things happen. It is the discretion of the judge to extract the truth from the other facts, and after extracting the truth, and he has to establish that these are the facts and these are the circumstances, these are the relevant facts, and these are the things which has to be accounted in the judgment. And after giving the judgment, he just evaluate and he just held either guilty or not guilty or acquit him. And there are so many provisions after that. This is a sort of criminal law, because criminal law is very important. Another thing, the public thing, the students say that they don't know the intensity of the criminal law, civil laws. They say that if the person has committed a crime, and crime is very famous and everyone knows how to deal with crime and how to punish the person and why he has been released and why why he has been granted bail. And other thing which I have just that is in between the thing is that in between the lines, that the provision of bail is also there whenever a person is facing trial and he has been inside the bail and has been taken to custody. There are certain restrictions to the benefit of the person. It is assumed that the person is innocent. He has not committed crime unless until held guilty. Therefore, he has been given full right and full opportunity, full everything that and that is the provision of bail has been inserted in the Code of Criminal Procedure to grant him certain relief and to certain thing. But the bail is in such a way that if he comes out of the jail, he shall not evade the evidence and he shall not destroy the evidence. He should be in such a position that he can get the bail for his only. And that's why sometimes the High Court grants bail after the conclusion of the evidence or some other thing happens or some important witnesses have been examined. Because it sometimes happens that while he coming out of because he's a certain type of person, he comes out of there and he used to use for violence against the prime witness and he gets benefit out of it. Therefore, the bail is to be given in the very special circumstances and keeping in view all the facts and circumstances of the case. This is in regard to the criminal cases, and the provision of the judgment is given in section 353 and what the judgment should contain and what the judgment should give, all these things. Section 5. And other thing is that unlike civil law, and in criminal law there is no review. If the judgment has given, the judge cannot overrule it or judge cannot amend it, because once the judgment has been written, that can be amended either substituted or amended by appellate court, not by the judge himself. This is one of the major things. And there is also provision of the compensation. The judge can, while they awarding the judgment, can pass the sentence and pass the pass the orders that the victim shall be compensated in terms of the money in case he has been there. And now the other acts has been developed, that is Posco Act, and in the category of the rapes and the different type of sections have been added, and all these things, and these all depends on the circumstances and another thing. No definite thing is there in the criminal law. Criminal law depends on the circumstances and the facts of the case. and the prevalent circumstances. If a person has been acquitted, it doesn't mean that he has not committed a crime. That's why the array of the courts is there. That is the different courts and different quality of courts are there to check the arbitrariness, to check the illegality, and to check the correctness of the judgment. So these are all about, and I'll be happy and otherwise after the lecture. So any one person, any one of you wants to ask anything regarding criminal law, I'll answer. That now comes with the civil laws. The civil laws, there's a provision that under Order 20. Now you are the you are on the way to be a liar. Therefore, you must understand the order and the section. The section is the bare law. That is the basic law, and the order is the procedural thing. That is under Order 20. There is a provision that how the judgment is written and what judgment should contain. In the civil law is very simple. That when two persons are fighting regarding the piece of land or regarding the drain and regarding the other thing is that if you have got house and other house is there and the overlapping of the house and that is the encroachment, then you can also file everything as there. The money, the simple suit for money. If a person has given certain money and he's not returning back, then there is the note and pronote and receipt and all these things. They'll have to submit before the court, and court after going scrutiny through all that time. Now the civil law is that there's a plaint, and that is given in Order 6. Order 6 is completely governs all these sort of plaints and all the things, and other thing is that everything is given on the back of it. In the Code of Civil Procedure as well in the Criminal Procedure, there are schedules. In schedules, there's a provision and there's a model, and you have to develop that model in order to give it the shape in the court. And the court proceedings are entirely different what you think it otherwise, because there's a set procedure how you approach the court and how you have to settle and how you have to put up your things inside the court and before the presiding officer, so that it will give a shape to the proceedings. It will give shape to your wordings and other things. And civil case, that's why I'm discussing the civil case. And civil cases, there are other things that if you are aggrieved with certain person, if a person is aggrieved that he has been denied access to something, or he has been discriminated or some other thing, that so many things, civil rights. And before going to this, the rights are concerned, because everyone has got legal right. And if you are if one person infringes the legal right of the other, then that is actionable, and action is inside the court. That is a tortious liability. And the other thing is that if the real fact is that the Specific Relief Act and the other Civil Procedure Code, and that is if you got some other disputes also, the mortgage and other covenant dispute and other so many, because civil law is just like a very deep subject, and nobody, and after 40 years I'm not able to read all these things, and every time I'll have to go through the scrutiny and books and all that, and that is not a one thing. So every time you will have to go through it. The law itself is not an abstract, but is a something which is like a sea, and you will have to go deep and deep inside to evaluate the things which are going inside. Similarly, the one person who I'm giving you the details only, the bare outlines only. That is, a person is aggrieved, he will present before the plaintiff, before the court of law, and say that I've been deprived, I have such and such, my property such and such, numbered such and such, and by description is can be described by number or by described by boundaries and this and that, whatever, and the court has got jurisdiction. And because there are limited type of cases and limited type of courts which can entertain, the SCC, the small causes court is, then if there money transaction, small money transaction, there's a small causes court, and there's a rent eviction cases, small causes courts, and other thing is the regular civil courts. And now the commercial courts have been established, and the commercial courts deals with the other things, and there were so many courts. The major thing is that the basic thing is that the whatever you if you are aggrieved, you just put your submission inside in writing and present before the court of law. That is a plaint, and plaint is description covering all these things by which a person is aggrieved. And when he submitted before the court, and that is then the court will itself examine it and number it, and then ask the other party to say something. Then the other party will rebut it. That is the written statement, and that is the reply of that whatever the person says that, and reply. And then there's a thing that how it can be settled. It can be settled by the asking both the parties to whether you have got any dispute, and that can dispute be settled by what. There are other things that Order 10 Rule 2. There's a court can limit the person that what is dispute. They can confine the person to the dispute. That is in Order 10 Rule 2 by taking a statement. Then what is actual wrong he has committed. Then to minimize the dispute. And then he frames the issues. That is, issues are the things that on which the judgment has to be given. And after giving the judgment, after issues, then each person has to give the evidence. And evidence is very vast thing that in civil cases. Civil cases evidence is role of evidence is very important. That is the something that if the personal vendetta is there, if the two persons are fighting in each other and other persons are not interested, that will be judgment. The judgment will come in. Judgment will be personam. And if it affects the entire community, entire word at large, then it will be judgment in rem. So therefore, there is a section 40 to 44 Evidence Act says that what are judgments in rem and judgment in personam. Therefore, the court has to adjudicate on basis of these things, that it will operate with others also, and other person will take benefit of the court order that court has passed in such and such. And one of the major things is that in these offences, there's a provision that immediate remedy. Because civil cases sometimes takes years and years together. Then how the person will be compensated? Then there's a provision that immediate remedy, that's called injunction. That is, a person is deprived of so many things and is continuously being deprived. Then he will ask the court to kindly inject the other person not to do all these things, because that will be negative in nature always. That was to restrain that person, but he can't say that I may be allowed to extract, I may be allowed to extract that, I may be allowed to construct a boundary of the house on that disputed land. No, but he can ask the court not to kindly inject the person that he should not start it unless until the dispute is over. For checking the dispute and for checking the arbitrariness of the matter, the court issues the temporary injunction for that, and that injunction is to operate for certain period, certain time, and in certain manner. That is to be defined, and that has to be ascertained, and in which in between there's another role of the advocate commissioner also. That is, or the what you call the civil that is the court's own person, the court's own employee, who goes on the matter on the disputed place, and thus he give a map, and he just sketches. He just prepare a sketch and then produce before the court, so that court may itself assess the damages, assess the matter in dispute, and then it evolves some certain remedies. And then on basis of this, the orders will be passed, and that order will grant some relief. And after that, the judgment is after giving the opportunity, that is both the persons giving the court shall grant opportunity to both the persons, that the person who has filed a case and the person who has been defending the case. Both the persons will come and will produce their own evidence and post defense, and then there's arguments. They will they supplement those things with their arguments, and the case, the judicial decisions as well. And the case of here the role of precedents, the law of precedents is very important. The law of precedents says that what is law of precedent? That is the pronouncement of the other courts, because if the precedents are not being followed, then it will be hodgepodge and it will be mesh of the thing that one court pronounces this, another court pronounces this. So the court of coordinate jurisdiction should pronounce in this certain manner, in this certain way. Otherwise, it will not check. So the law of precedent is very important. Certain courts say, and the certain say the High Court has given this ruling, and the other says that the Supreme Court has cancelled it, and Supreme Court has passed a recent pronouncement in this case. Therefore, law of precedent plays a very important role while deciding the civil cases, and civil cases therefore are dependent on the law of precedents also. And these all this extract of all these things is a judgment. And when the court reaches on the judgment, then passes the judgment. And judgment is not one thing and another thing, but a common disposition and common extract of all these things, and then judges reaches conclusion and then passes the order. And then afterwards there's a hierarchy of things, that is the appeal and other thing, revision, appeal, and so many things that the other person can enjoy. But the extract is then the judgment is that. Judgment is therefore not one thing, not one citation, but one is a. And in civil cases there are a different, and when there's a difference between the facts and case, that will the precedents of will not apply. The precedent of law of precedent will apply only those cases in which the exact findings, exact facts, the facts are very important. And there are certain laws also which sometimes takes, say, for example, the other acts also, that is the Land Acquisition Act, that is a person as plowing the field, and that the common road is being to be taken into account, and common road is being built by the CPWD, and the government acquires. Then the acquisition rights are also there, and the person giving the land should be compensated in terms of money. That is to be given. That is another law, another act, and that is another civil proceedings. And the civil proceedings are numerous. Therefore, simplest of the things I've told you, that on which basis the cases being fought and the cases are being recorded and the evidence is being recorded, and then the person is given a this fair decision. That's called fair decision, and then they participate in then they fight each other and to control each and everything. And these are things because to check the to check the vandalism and to check all these things, the court functioning is very important, because court in fact abolishes all the things which a person can occupy with use of force and use of other things. In order to check that if the person is unnecessarily occupying land and other thing, then other person will come and quote and say that I have been deprived of these things and this is my livelihood, and therefore it may be staying. Then the check. Therefore, the role of the court is very important, as well as civil court as well as the criminal court. Both courts' role are very important to check the peace in the society and to check to govern the society and to other things which for the harmonious living of the persons. And I'd like to answer any question which you'd like to have.
Sanma sir, can you hear me?
Yes, I'm here.
So please have a peek for the entire event and everyone. So please ask everybody to turn on their camera and have a peek for our file.
So I would request everyone.
Yes.
Yes, sir. I would request everyone to put on their cameras, please.
Yes, who is going to ask the first question?
Sir,
Sir,
so we have got
1 minute, you sir. All students, please turn on your camera quickly. We have a photo right now. Dear resident, all of you, please turn on your camera quickly. And faculty member also, those who have joined, please turn on your camera. Yes, Tanna sir, you may take now.
yes. Sir, it was indeed a very a very engaging and a very satiating session, sir, and we are absolutely privileged to have you over, sir. And we have got certain questions, and I would
Yes,
like to
yes.
ask, yeah.
Yeah.
So Navya, you can take
You
over.
have taken the pick now.
So
Yes,
the
sir.
questions are as follows. So
Yes.
the first question that we have received is, since the law profession is inherently based on sound judgmental skills and reasoning, what can be the basis on which the skills can be enhanced?
Yes, the skill, as far as the liars skill are concerned, that is purely, have you must have said, what I have said earlier, that is not a right alone or might alone. It's just a, probably the skills can be developed only by the argumentation and the knowledge, and by the psychological thing, and by the approach. If you have got good approach, if you are studies, your studies are good, and if you go through the deep, the facts are very important in either in civil case or criminal case. Unless until you are very well versed with the facts, then you can't say anything. If you are well versed with the fact, then you can ask what law should be applicable for that, because the law can change, but the facts cannot change. The facts are very important. The only thing is that for acquiring the skill, you must study hard and hard, and you must know the facts, entire facts, and then facts are to be applied in the law, and that then you will be a good liar. If you can apply your law to the facts, then you will be a good liar, and you know what legal opinion is to be given for that. Am I clear?
Yes, sir. Thank you very much. The second question that we have received is, in a largely unethical world, how to balance between sound judgment in face of corruption and low moral values?
That is a corruption, as far as things the court is based on the paper justice. Whatever you say, the court is not superhuman. Whatever court can gather the information from the record and the police record and the other person who is making allegations, and the person making allegation is naturally as a person who is offender, and he is making allegation, that is it has to be adjudged very carefully that whatever he's taking, asking is correct or not. Then you will have to evaluate. The duty of judge is to evaluate, to understand what he's saying, what type of his character is, what type of person he is. If he is himself a goon, how can you say that he person is telling correct? And if a person is honest person and person say that, so I've done such and such, and he's an innocent man, and either he's a professor or is a doctor or something like, and he says that he has seen something, then that has to be believed. And similarly, the police says the other and is police. The police submits that this is the person. The previous conduct is this, and this said that, and he has been found this and that, accepting bribe and accepting corruption, and he was guilty of encouraging corruption. That is, the court will take its view and will determine otherwise.
So
The court has itself has no court based on the facts and circumstances of the case. The judice, that is against the prejudice. What is English dictionary is prejudice, and judice is different to that, antonyms of that. That means one who is not prejudice is a judice. That means if you are saying, if you are sitting on a chair and you should be calm and quiet, you should hear both the parties and then take a decision. That is the skill. And whether, and that is why the hierarchy of courts are there. Otherwise, there should be one court. And I tell you what are the examples. And in the olden days, what was happening? A person, two persons were quarreling. One was the mischief monger, and another person was an oil merchant. They say that the oil merchant laid allegation that the mischief monger has taken so much money against me, and he was due was only that, and he snatched so much money. Then they both went to the Qazi. Then those times there was no laws and other thing, but Qazi was so intelligent that Qazi said, all right, show me the money. But the mischief monger said that this is the money. And then he took all the money and poured inside the water, and he saw that the oil drops are coming out, and then he handed over entire money. And this is the start of justice. The justice is to be by the skill and by the, if the judge is so expert in these matters that he gains, and whenever you will be, if you seek the examination, and you are the judge, and after the 4 or 5 years you will immediately can guess what is wrong and what is right, although there is no evidence, but you'll say that he must have committed crime, but since he managed therefore you can't punish him, otherwise he's a guilty. These type of things happen.
Yes, sir. So the last but not the least, do judgmental decisions supersede logical thinking?
Yes. In fact, logical thinking is there's a law of precedence has already given you. If a superior court set aside the judgment of the previous court, that is, however, maybe logic, then that will not be enforced, and the other lower courts will, other courts will not follow that. The only thing is that hierarchy of the court, and that is to be maintained because this is something should be the pillar of the justice. That is, if you make certain laws and certain that is, if in case of race, there's a some line and there's some end of that. If you reach to an end, that means that is a correct. That whosoever reach first, that will be given the prize. That's why if a law has been superseded and another law has been created, then the law prevalent at that time will be applicable and not the other law which has been superseded.
Thank you, sir.
That is the arbitrate, check the arbitrariness only.
Yes, sir. Thank you, sir. I extend my gratitude to Honorable Justice Zaki Ullah Khan, sir, for enriching us with deep insights into the topic. We believe, sir, that your inputs would go a long way in shaping students' knowledge and understanding for the judgmental skills as they move ahead in their pursuit for legal excellence. Now, I would like to request Professor B.K. Yadav, Principal, Center for Legal Studies, Gibbs, to deliver a vote of thanks to Honorable Justice Zaki Ullah Khan, sir.
Respected Chief Guest, Honorable Justice G.V. Khan Sahab, my dear faculty members, and my dear resident. It gives me an immense pleasure to deliver the vote of thanks for this event to all the dignitaries assembled. Today, Sir has explained very important points to all of us. We used to read only the articles and barracks in the class. And judgment skill is very much different. It's totally different thing other than the article or sections or the barracks which you read. Sir has explained in very beautiful words how the evidence is being recorded in the court, how the hearings of the court is being recorded in the court, what special skill is required to write the judgment. Dear student, you just compare one thing with you, that you are the judge of a court and you have to write a judgment. I am 100% believe that you will be nervous and you will not get the words to find out the words to write on the paper, how to write the judgment. So really, judgment writing is very, very difficult work. And only the judges, those who are practicing in the courts, they are only the right person to know the skills of the judgment. And these judgments are judgment skills are very, very required for each and every student, because you students are going to become a lawyer and then you will crack the judicial examination and then you will be the judge. So those students who are attending this seminar, I must believe that they have got new things regarding the judgment skill, and really it will be very, very helpful for all my students. So once again, I would like to thank Sir. Sir has managed some, valuable time for us, and he has explained all the things in very beautiful words. So we are all grateful to Sir on the behalf of Vidyaratan Business School. So thank you, Sir. Thank you once again, and we are respecting that we should have a long association with you, and in coming session also you will just manage your time and you will come our program and you will impart these types of important and valuable skills and knowledge. Thank you very much to all of you, sir. Thank you.
Okay, thank you. My pleasure.
Thank you so much, sir. With this, we come to the end of the workshop, and with the hope that the knowledge gained would keep us in a good state. I once again wholeheartedly thank our esteemed speaker. In the same vein, I also thank Professor B.K. Yadav, Principal CLS Gibbs, for being instrumental in organizing the session and for being the guiding light in the run-up for the same. In addition, I thank Dr. Tanmay Pant, Assistant Professor Gibbs, for being the coordinator of the event. Lastly, As the most important stakeholder, I thank the students for being active learners and making the session worthwhile. Thank you and stay safe.
Thanks.